Thank you so much for joining us this afternoon to talk about the upcoming arguments in Trump versus United States. This is the second Law Dork video, and we have the fortune of having with us people involved in two of the key amicus briefs submitted in the case. Kathleen Harnett, a partner at Cooley, who worked on the retired general's brief, along with Kristy Parker, the special counsel at Protect Democracy. The third member of our panel today is Holly Brewer from the University of Maryland, who was involved with the brief brought by the founding scholars of American history. I'm really excited to have this conversation. I've obviously been spending a lot of time on this case as it's been going through since Trump started challenging, making this claim that he has absolute immunity from criminal prosecution for official acts for life. And that is basically exactly what the question presented is to the Supreme Court when it hears arguments on April 25th. Going into this, I think sort of my first question is for you, Kristy. Sort of the scene setter, how we got here. I know that you all at Protect Democracy were involved in trying to keep the criminal case going while the Supreme Court took it. But can you sort of set the stage for how this case evolved, that we ended up having this side argument about criminal immunity before Trump is even going to trial?
Well, sure. So, as I think we all know, former President Trump was indicted last summer a couple of times by federal grand juries. The first was in a case involving national defense information, classified records in Florida. And the second one was indicted in Washington, D.C., arising out of the insurrection that took place on January 6th. And the charges in that case are a fairly wide-ranging set of conspiracy charges around that event, which include, a conspiracy to defraud the United States, a conspiracy to obstruct justice, and a civil rights conspiracy to interfere with people's rights to vote. And long story short, it includes a lot of alleged agreement between Donald Trump and unindicted co-conspirators and others to secure false electoral certificates, to cajole federal officials into setting aside lawful election results, to pressuring the vice president to disregard his duties, to co-opting the Justice Department, to try to open fraud cases that were unwarranted, and also to direct a mob to the Capitol and then basically leveraging that mob in order to continue his efforts to try to get the vice president to not certify the election. So after the case was indicted, Trump filed a number of motions to dismiss, and the central one of which we're here to talk about, asserting that the president enjoys immunity in a criminal context, much like the president has been found to have in the civil context emanating from the United States versus Nixon case. And, again, just to cut to the heart of it, that's an unprecedented claim. It has never been thought that a president enjoyed immunity from criminal prosecution as opposed to civil damages liability. There's nothing, the Constitution does not speak to that. And frankly, all of our leaders, and as the briefs that we're here to talk about discuss in detail, have understood it to be the case that presidents are not above the law and that they are subject to the very laws that they are required to enforce. Nixon accepted a pardon based on his understanding that he could have been indicted. And as we know, a pardon is actually an admission of guilt. So that's sort of the scene setter, how we got here. He filed this immunity defense. It is something that allows him to take appeals before the end of the case, which is not customary in criminal cases, but arguably attaches to an immunity defense. So we've gone through the DC Circuit, and now we're at the Supreme Court.
And now there was originally an attempt to get sort of a leapfrog over the DC Circuit and to have this considered as early as probably January or February, and the Supreme Court denied that. Does anybody have have any thoughts on that and sort of the timing of this case in terms of why we're here now as opposed to why the court didn't take it sooner?
Well, the timing of this case is extremely important. As we know, the defendant is the former president, who is also the presumptive nominee for the Republican Party for the 2024 election. The charges he is facing involve an attempt to interfere with a lawful election to stop the peaceful transition of power when he was president the first time, and he's seeking to reassume that same office and be in a position to do similar things again. So time is of the utmost in order not to decide the election. Voters will decide the election no matter what. But for the public to hear the evidence around those charges and for a jury to, decide what to do with them in advance of voters being asked to consider the defendant's candidacy. So that is, I think, why the special counsel's office refrained from saying so explicitly, but they certainly argued that time was of the essence in the case. And that is why they sought to skip the DC Circuit and seek a writ of cert before judgment, which is unusual, but not unprecedented, and has happened actually quite a lot in recent times, particularly with this court. And if you look at all that has transpired in the few months in between, given that the Supreme Court went ahead and did decide to take this case, it seems like the special counsel's arguments were well taken. And from a public interest point of view, and there is a public interest in speedy resolution of criminal cases generally, and certainly particularly so in one like this, it would seem in retrospect that the special counsel's arguments were well taken, and it would have been a good thing for this to have gone before the court several months ago when the special counsel asked for it.
I will add to that there's been consistent efforts by the Trump team to delay justice. And in the early modern period, in the years after the revolution, when the Constitution was being designed, it was assumed, I think, that any case like this would have been heard within a matter of months. So it would have been heard not, within, we're coming up to 4 years since these events happened, and this should have happened within 6 months or less. And so there's so many technicalities now that have been used, that have intervened, and also so many attempts to delay justice from the Trump team that something that should have been heard right away and disqualified Trump probably from becoming the official nominee did not happen in a timely way. So
I might jump in too with one other thought I had about the timing issue, because I think the normal practice would be for the Supreme Court to wait for a federal appeals court to rule, and there have been some notable exceptions, and we can kind of bracket whether those are wise or not. But I think here, in a way, I think the special counsel kind of had to do that because it precluded an argument later that they had sat on their hands and had not kind of sought review quickly. And there's these other principles about like rulings too close to the election being a problem. And so I think that was an important box to check, even if they weren't going to get the review. I also think we now kind of have the DC Circuit, the benefit of that ruling and the questioning and answering that happened at that argument that have helped to kind of gel the debate. So kind of regardless of whether it would have been better to have this all happening sooner, in a way, it did kind of illustrate how it can generally be helpful to have the normal process play out. It just would be nice to have it play out, as quickly as possible.
And it's certainly the case that, however this all shakes out, if we get a decision, and really based on the way that the Supreme Court treated the issue with Trump's potential ballot disqualification in the Anderson case, we should not see them waiting all the way until the last day of term to issue an opinion in this case. But if we get into a situation where there's the potential for a trial very close in time to the election, the person responsible for that will have been former President Trump, who was the one who has asked for all of this delay. You know, as Kathleen rightly points out, you know, one feature of the special counsel's effort to get cert before judgment would have been to have the trial much further away from the actual voting
Right.
than it may well now be.
The March 4th date that we all remember was the original trial date that obviously we're now 5 weeks past that with no clear set. So the case was granted, and we have these briefs coming in, and I just to go through it, I looked through the Trump and special counsel's briefs, and you sort of have these, both sides sort of go through this like 3-tier argument where Trump is arguing that there's absolute immunity. The special counsel's arguing that there isn't absolute immunity. And then Trump argues that if there is immunity, if there isn't absolute immunity, there should at least be qualified immunity, whereas the special counsel argues even if there is some immunity, it shouldn't be used here. And then at the end, both sides say that regardless, if you don't agree with us completely, this can be dealt with on remand at trial. Which I thought was interesting in a way, because obviously the special counsel, that gives them a chance to argue that these that there were enough non-official acts even if you find immunity. But obviously, and you can almost read it off the pages of Trump's brief, like this would be more delay for Trump if it gets remanded. And so I guess, Kathleen, can you talk about sort of like what is the setup for these arguments, and like what we're going to be seeing from John Sauer and Michael Dreeben on the 25th?
No, that's a great question. I think it kind of you can never totally predict, and I think that in a way the parties briefs, and we just got the reply brief from Trump today, so we're still reviewing that, but kind of want to reserve. You want to lead with your full-throated argument and try to make it about, you know, a full win, but you also want to have your backstops in the brief to make sure you're not going in with the full win and having no one agree with you and then not have much to stand on. And so I agree with your assessment that it seems as if both the special counsel and to some extent Trump are trying to find ways to make sure that they're kind of more maximalist, I guess, for lack of a better term, positions on each side are not, you know, kind of the only thing they can talk about if the court ends up trying to be interested in a more minimalist resolution. I mean, in a normal circumstance, and again, it depends on the case and the situation, the court has not typically, or at least historically, been interested in trying to maximize rulings where it doesn't have to, and trying to find something that fits more the facts of this case. So you could imagine a ruling that they don't need to resolve the ultimate question if there's enough, for example, non-official acts or some other way to kind of reach the narrower result. But on the other hand, again, the parties spend most of their time trying to take on the maximalist position. So it'll be interesting to see if the court wants to take it somewhere else.
And I mean, so I went through these arguments, looked through the briefs, and it seemed like the two briefs that really stood out to me were these two briefs, the former military officials brief and the founding scholars brief. And the line, and we'll see if how you feel about the lines that I chose that I thought were really interesting. That in the military brief, this idea that our legal system does and should continue to subject the president to criminal laws, just like every other individual in the chain of command, thereby lessening the likelihood that unlawful orders are issued in the first instance. Kathleen and Kristy, can you talk about this concern? I feel like the brief really gets into this idea of something that hasn't been discussed as much in the context of the Trump case, but just sort of the actual fact that, like, we're talking about the former commander-in-chief here, that he's not just a the executive who's signing bills and making administrative rules, but that this is actually the person who was running our military when he was in office.
Yes, no, that's a very good point and kind of an important piece of context to keep in mind. So our brief was on behalf of 19 former high-ranking officials in the military. We had 4-star admirals and generals, former secretaries of the U.S. Army, Navy, and Air Force. 19 of those folks who had served from every administration from President Kennedy to President Trump. So I think we felt happy, and that understates it, I think, to have the power of that collective thinking. Kind of bipartisan and nonpartisan, really. It's a brief about military civilian, the relationship, which maybe, kind of less known. I don't believe current members of the court have had military service. I could be wrong on that, but it's always instructive for people that are not part of that world to kind of understand it more, and in particular, what it means for there to be an order coming from the president, him or herself. And so I think in this situation, the amicus, I hope, is kind of serving the real function it's meant to as a friend, which is to point out some context and important context and reality that may otherwise not be part of the formal legal arguments. And here is, like, how does it functionally work to have the commander-in-chief be the civilian head of a military force? And what does it mean to have the important trust and other relationships that are necessary to have that function well and to continue to function as the protector of a free society? So I think the notion here was, and that the line you focused on, is at the end of the day, it is unlawful. A member of the military should not follow an unlawful order. But the question here is, among other questions, how do we kind of continue to make the likelihood of that having to happen as low as possible? And so I think our brief, among other arguments, points out that removing the kind of understood notion that there would be a potential criminal liability for the commander-in-chief, were the commander-in-chief to undertake a criminal act, would both just demoralize the force, kind of break down those bonds of trust, but also really possibly increase the risk of people not disobeying an unlawful order. So I think those are some of the key points we were trying to make through the very deep experience that our amici have in this sphere of how does this really work in practice.
Kristy, it was sort of wild understates it, but just jarring to read an amicus brief that is discussing the My Lai massacre at length. Can you talk about sort of the discussion of that and how you decide to talk about that in a brief to the Supreme Court?
Sure. And that was a really seminal event in, I'm sure our historian here would say very recent American history. But that was an event that really just crystallized how actually difficult it is and this is not to excuse it at all, it's very clear and has been clear certainly since the Nuremberg trials, well established that people who take an oath to the Constitution and to the law, and in particular people in the military, have a duty to disobey unlawful orders, and that it is not a defense to any criminal liability to say, I was just following orders. But what that incredibly, that it was obviously unlawful order was given there. What happened there was a war crime. It was disastrous for the victims, and it was a disaster for the credibility of the United States, and a disaster, domestically for our politics. And some people did resist the order and later were commended for it, much later. But William Calley didn't. As unlawful as it was, even given other people who were resisting, he did not himself resist. And that order did not come from the President of the United States. That just came from his direct chain of command. So one of the reasons we thought it was important to give that as an illustration, and our amici, certainly thought it was important to give that as an illustration, because it would be even more difficult coming from the commander-in-chief, him or herself, to actually defy that order. And frankly, the doing of that, which is we've never seen in American history, would itself, set off a constitutional crisis. And I'll just say, I found it, personally really impactful to hear our amici raise that example, because I prosecuted government officials for violating their oaths of office in police misconduct cases. So you've got a duty to resist an unlawful order to, do what right. happened with Derek Chauvin to George Floyd, or to do what happened with Rodney King, 30 odd years ago. Those folks have a duty to resist that sort of unlawful order. But we see throughout, history how very not often it actually happens because of the pressures that people are felt to face. So it was really important to crystallize this for the court and have it come from people who understand what it's like to be in the heat of battle, and to have them explain it to the members of the Supreme Court so that they'll understand, what the stakes really are here.
Can I just pipe up here?
Yeah.
This was an explicit concern during the Constitutional Convention, during the ratifying conventions, particularly that the president was commander-in-chief and would have this extraordinary power. How do you make sure that power is adequately checked? And so putting in the possibility of not only impeachment and removal, but also prosecution was crucial to making sure that the president didn't sort of easily become a tyrant and do exactly what we're talking about. And it was one of the important conditions in the ratifying conventions. This was thoroughly vetted, this question of would there be these checks on the president, because of exactly the situation that's raised in this other brief by military officers.
When Holly, to that end, in your brief, I thought it was pretty remarkable in light of the discussion that we've been having over this past year now about Trump's immunity claim, when you sort of lay out the actual sort of some inaugural justices of the Supreme Court who said the exact opposite of what Trump is arguing today. And it just the aggressive line that I saw in your brief was this: to justify Trump's radical assertion, he contends that the original meaning of the Constitution demands it, but no plausible historical case supports his claim. Can you talk about sort of
Sure. So
what the history was?
Sure, exactly. I guess I was so I was asked to be on the Brennan Center's Historians Advisory Council in December, or actually earlier, but I was talking to them in December, and I said I thought the Supreme Court would take this case up precisely because of how presidential immunity claims have been gaining steam, which essentially are what Trump's lawyers have been arguing, that essentially presidents have the powers of kings, including some level of immunity. And I knew from having read so many of the original treatises, like Just Joseph, like Story, like St. George Tucker in the original, that they had explicitly rejected keeping the common law powers of kings, and particularly in terms of immunity. And so I knew that perspective was really important to get it out there, but somehow nobody seemed to realize it. But as part of writing this brief, we went back comprehensively through all of the constitutional debates and ratifying debates. And what was really startling when we did it comprehensively was there was no voice, and literally none, that made this argument. And a lot of Federalist Society lawyers, I don't know what the best word, law people who have taken the position that there is a unitary executive who has certain kind of privileges, emphasize in particular Alexander Hamilton's speech at the Constitutional Convention, where he said explicitly that he wanted a lifetime executive, and people have said, oh, that's sort of like he wanted a monarchy, etc. But Alexander Hamilton explicitly said during good behavior, which, if you know the legal debates of the 17th and 18th century, those are code words, which mean impeachable, prosecutable, remove. This is about removing corrupt officials. So there was not even Alexander Hamilton, who, if anyone might have come the closest, not even he took this position. There was literally no voice. And the other side has occasionally chosen a quote from the Anti-Federalists to say that some at the ratifying conventions thought the president was too much like a king, but these were always objections to say they had this under the Constitution. There's not enough checks on the president's power. So George Mason was one of those who was a member of the original Constitutional Convention, but then in the end was an Anti-Federalist, exactly because of this concern.
Now, when we move forward and we have the arguments, obviously we're going to have Michael Dreeben up there, who was in the Solicitor General's office for a long time, is sort of one of the leading criminal lawyers before the Supreme Court. And then there's John Sauer, who is Trump's lawyer, who, if anybody listened to the DC Circuit argument, is where we got into a lot of these sort of winding loops that Trump has been in, where you got the headlines that you would be able to call for the assassination of your opponent, and Sauer couldn't answer it. What are you going to be looking for at the arguments on April 25th? And we can do a little round robin here, starting with you, Kathleen.
No, thank you. Yeah, it's going to be, I mean, going to be interesting. I mean, it's hard to know. I mean, each of the, in a way, it always, at some level, the advocates in front of the Supreme Court are sort of players, but not totally driving the discussion. The questions will come, justices will potentially engage with each other through the attorneys. So, right. Each of them will be coming in with potentially a different approach to either building consensus for their position or narrowing the question to something that they think they can get a, majority for. So I think things to look for. I think with a less, I mean, as you pointed out, Michael Dreeben's a very familiar face, less so, in the years he's been out of the SG's office, but he will be known to the justices, someone who's been before them on important issues for many times. And so I think he'll be a credible voice, but they'll push him. I think the newer comers will, have a challenge, but I think which can be frustrating to the justices if they're not at the level that the advocacy needs to be able to kind of deal with the questions quickly and move on to the heart of things, which is what they want to do. But I think they're not going to spare any punches. If we've seen, from some of the other recent arguments where there've been, relative Supreme Court novices trying to take that on, they're going to want to, this is important. Also, just the way that the arguments are proceeding now, with letting the person that's advocating get their couple minutes out before the questions start, and it could go on for some time, especially if people are feeling like there's this is a chance really for the justices to talk to each other. And so I think this could be a long one in the sense of just seeing how the arguments unfold, if there are any new concessions or other kind of provocative remarks that need to be developed. I think it's just unpredictable. I would be interested also just to look at the former federal government lawyers in particular to see how they react to this, because the rule of law is something I was fortunate enough to be in the government for a few years. It's just something that we take so for granted, and so to see how those folks react to this argument will be interesting to me.
Holly?
Hi, yeah, I think the thing that I was happiest about in terms of our brief was that Michael Dreeben wrote us a note saying it was well done, which was so cool, so incredibly cool. But what I noticed, and what spurred me to action in terms of volunteering to be the main author on this brief, was the widespread claims that I've been seeing in all of the all of Trump's lawyers' materials, that the chief executive under the common law had traditional powers that continued to be the powers of the president under the Constitution. And the chief executive under the common law was, of course, the king. It's not, they never say a king. They just say chief executive under the common law. And that one of the things I'll be looking for is we have now provided the material to say that that part of the common law was explicitly rejected, not only by the Constitution itself, but by all the justices writing about what of the common law applied after the revolution and what did not. So I will be looking for quotes from St. George Tucker or Joseph Story or others showing this explicit rejection of monarchical prerogatives for the president. And then the second thing I'll be looking for is the actual, I guess, the actual quotes from the second point I'm looking for, sorry, is that in terms of Joseph's story in particular, it was so impressive the way he took apart the argument of the purpose of impeachment and conviction in the explicitly in his 1833 treatise, the first treatise on on constitutional law. He took apart the why impeachment was separate. And he said, impeachment and removal is just about removal from a political office, but that doesn't mean that the president isn't also subject to the criminal law. And he has pages where he explicitly addresses not only why it's a separate process, but why it's so important that there is this accountability, because the purpose of the president, the only purpose of the president, is to take care that the laws be enforced appropriately. And if a president can do whatever he wants, that violates the 100% the purpose of what a president is supposed to do. So it's those two parts of our argument that I think were least known and can provide the best ammunition in terms of the defense, in terms of what Jack Smith's team are trying to answer in terms of presidential accountability.
Yeah, I was actually going to ask a follow-up about the impeachment question since
Yeah.
came up. So you took care of that. Thank you.
Okay, sorry.
And Kristy, what are you going to be watching for?
So I think from a very practical former prosecutor point of view, I'm going to be looking for indications about whether we're going to get an expeditious decision in this case, whether there appears to be broad agreement around the question that there should be no broad-based immunity from criminal prosecution for a president. There certainly should not be immunity under the circumstances in this case. And I think, we don't want, I will be hoping not to see anything that indicates that there's going to be a remand that will entail further delay. And we really should not see anything like that. I think one of the things that's important to point out here is just how much unanimity there has been in the legal community, both the community of lawyers and also the judges who have heard these issues, that there should be no general immunity from criminal prosecution for a president. And there certainly should not be such immunity for the acts that are alleged in this case. And, it's a broad cross-ideological group of people. We've had people like former Judge Michael Ludig, who is a mentor to some of the justices on this court, who has said that he thought the decision should be 9-0. We've seen briefs from former Federalist Society members discussing why there should be no immunity in this case. And when we look at the judges who've looked at it, it's a bipartisan group of judges. We had the Democrat-appointed district court. We had a panel on the DC Circuit that included Karen Henderson, who's a George Bush appointee. And when you look at the specifics, when you talk about the question of, well, maybe there's some immunity, but there isn't immunity for other things. A separate panel of the DC Circuit that included Judge Katsas, who worked in the White House counsel's office with former President Trump and who shepherded the nomination of Justice Gorsuch to the court. He was on a panel that said, acts very similar to those in the criminal indictment were not official acts, were, the acts of an office seeker and not an office holder. So there's been a lot of uniformity on this issue across the ideological spectrum. So I would very much hope not to see anything that indicates that this court is going to go a different way, or anything that indicates that they are going to further delay this case. Because I think, as we all know, the court's own legitimacy as an actor within the three branches of government, and as an actor in a democracy, is also on the line here in a case like this, where we are seeking to hold accountable someone who is alleged to have interfered with the peaceful transfer of power and mounted an insurrection to overturn a free and fair election. If we can't impose accountability for that, as our brief points out, democracy around the world is one of the things our military defends and promotes. And we don't want to give ammunition to the people who say that our democracy isn't what we say it is, and is a lie. And if we can't have accountability in this situation, we would be running very close up against that problem.
Thank you so much. Does anybody have any closing thoughts? Anything that you needed to get out that I hadn't asked?
I have just one thing. I think what was really astonishing to me in reading St. George Tucker's treatise on the first American edition of the common law post the Revolution was that when he was discussing this, his hypothetical case of when a president should be prosecuted sounded a lot like what happened on January 6th. So he actually says, let's see if I can find the quote. Sorry, I thought I had it up, and then it turns out I of course had closed it. If a president of the United States should, by his own authority, presume to raise an army, so this is St. George Tucker writing in 1803, if coupled with evidence of a sinister design and intention of so doing would, I conceive, amount to an overt act of treason against the United States, such a president, he writes, would be subject to impeachment and then to criminal punishment. And it's just, so when you think about the insurrection, I guess it's not quite an army, but certainly there's an element to that, calling everybody to come on that day. It's just, what was so striking is to see St. George Tucker in this book that was used to train generations of judges and lawyers in the founding era. His hypothetical is so close to, obviously Trump is being charged with slightly different things, but this is exactly what they were most worried about.
And that is a point, I think, that brings both of your briefs together, which is really interesting to me. It's sort of like from the beginning of the country to like the military leaders who led it over the past 50 years, that sort of this concern in particular relating to the transfer of power, both in the underlying principle of the country and the sort of democracy spreading goals of America, that this particular case makes it all the more concerning. So I really highly recommend that people look at both of these briefs before the arguments on the 25th, and we'll see what the justices have to say about either of them or both on the 25th. So thank you so much for joining us, and I look forward to talking with all three of you again soon.
Thank you for having us.
Thank you.
Thank
Chris.
you.
Nice meeting.